Welcome back. As we get into our early morning discussion, we invite Martin George. He will join us on the Zoom line to, as always, give counsel and guide us with some of the developments. Martin, great to see you. Good morning.
Yeah, hi, good morning to you, Jason, and good morning to your viewers.
Well, of course, I know this morning you are coming in with well, as per usual, your attorney at law cap this morning. And we look at the situation in the country where the backlog, you would have mentioned this time and time again on the program, going into the prison system. When I went to talk with the prisoners for Mandela Day a couple of years ago and to host their Calypso competition a couple of times, I would talk to the prisoners, and I've recognized that the frustration, especially when it comes to those in remand, it's from that fact that they've been waiting for years, sometimes 5, 6, 7, 10 years, to just get a hearing. It's over 15,000 cases in the system. It's a backlog. And Friday, the debate started there in the House to try to amend and fix this particular situation. Do you see this bringing any kind of ease anytime soon? Could this trial by judge alone truly help this dire circumstance?
Well, the thing is, Jason, I mean, we already have it as part of our judicial landscape where it's optional. What it appears is that you're now looking at a scenario where it is sought to try to make it the standard, as if, well, you know, in all circumstances, you therefore now go to a scenario where you go to trial by judge only. And that is where you see the opposition, and you see some of the independent senators have spoken out repeatedly against it, because they think that this in some way represents an incursion on the rights of individuals to be tried by a jury of their peers. And that is not something that you take lightly in terms of seeking to remove it or have it, off the table. Because if you look at what has happened in Australia, Australia has been experimenting a lot with this idea of the judge-alone trials. And the results have shown that, first of all, less than 10% of persons opt for it. And the results also show that in terms of the results, the verdicts in the judge-alone trials, there's a much higher rate of conviction, a disproportionately higher rate of conviction as opposed to the jury trials. So therefore, someone who is before the court on a matter may feel that, look, if you take away my right entirely to a jury trial, then basically I am now running a greater risk of a conviction. And this is just based upon, as I say, I'm using the statistical evidence from Australia, which has been experimenting with this judge-alone trial system. So you have to consider that. Of course, on the other hand, I know the argument put forth by the state is that, look, it will save time, it will save cost, and, you know, it will help to speed up the judicial system. But the real clog in the judicial system is not the jury selection process. It's not the fact that juries have to decide matters, because even when a jury has to, retire to consider their verdict, okay, Jason, even if they take 3-4 days, maybe a week, that pales in comparison to the 5-10 years you're saying that people are on remand. So that really is not the reason. And a jury selection process in Trinidad and Tobago, usually, in the criminal courts, that is concluded within a day or two maximum. We don't have the long interrogations that you see in other systems, like, for instance, in the US, where they question each of the jury members, almost like cross-examining them. We don't have that. So therefore, I'm not sure in terms of speeding up the system if it is going to really make that difference. And in other words, you end up maybe trying to sacrifice, the rights of persons in that regard on the altar of expedience, trying to say, well, look, we're trying to get a faster process here.
Well, Martin, the system clearly is broken. It leaves so much to be desired. And I go back to the statement made by the Honorable Ralph Gonsalves, Prime Minister of St. Vincent, at the recently concluded crime symposium at Hyatt. And he made such an important point. He mentioned that he believes delay is being used as a defense mechanism. The fact that some of these cases are taking so long, not only here in Trinidad, but clearly it's something that's happening also in other parts of the region, where cases are taken long before they are heard in the court of law. And because of that, people's memory might get a bit cloudy. There are those who might migrate, people who will pass away. Key evidence is now being lost. And sometimes when the perpetrator or the person held is before the court, they are now just given time served and the case is dismissed. Sometimes I wonder if the situation we are in is by design.
Well, the thing is, I mean, we have to understand that delay is a two-way street, you know? So, I mean, while you may have scenarios where defense attorneys may sometimes ask for adjournments and, you know, they may file applications, and that will, of course, delay a matter. We also have to remember, in many cases, the prosecution in Trinidad and Tobago is very often not ready. And you heard the lament of the DPP recently, Mr. Gaspard, where he, you know, complained that he's so understaffed and under-resourced and that he's not able to man all the courts properly due to the lack of staff and resources. So the thing is, the reality is that if one were to really do the statistics, I'm not sure that it would necessarily be skewed so heavily to show that defense attorneys are the ones who, you know, cause the delays through the adjournments. Because you have to consider also, Jason, if it is that a person has a legitimate right to be able to file an application, say, for instance, to the High Court or the Court of Appeal by way of reviewing a decision of a magistrate during the course of his matter, then the exercise of that right cannot be cast or, you know, put as a, you know, delaying tactic, because you are exercising your legitimate right. What we need to do, and as we have discussed previously, and I have, you know, made mention, is maybe you need to have, particularly for the high-profile matters where you will expect these types of applications, we need to have dedicated courts sitting to deal with such matters. So in other words, if it is that you set aside a magistrate and you say, okay, look, you sit in the, you know, where they had created the court in Chaguaramas, you know, so you say, well, look, you sit there and you deal with something like, say, for instance, the Piarco inquiry, and you deal with it from day to day to day. If it is that someone files an application, then you have a judge assigned immediately to hear it. You know, if it goes to the Court of Appeal, the Court of Appeal convenes immediately to hear it. They deal with it, and one way or the other, the matter goes back to the court, either, you know, for dismissal or continuance, depending on the result. But we need to look at it from that perspective, Jason, more than to simply say, well, you know, it's a question of delay, because I think really and truly, if we were to do the hard and fast numbers, you would find the prosecution in many occasions, the party that is wanting and, you know, the party that is seeking the adjournment.
And I mean, you would know because you're in the system, and I want to thank you for that clarification, because I know that statement would have come from the Prime Minister of St. Vincent, and I was like, wow, that's a sharp commentary there, and the space and in terms of the platform that he made the statement to was very profound. I want to go back now to the, yes, and I want to just go back really quick to this judge-only trial scenario. How lengthy is it now? I know you mentioned sometimes it could go from a matter of hours to days to come to a judgment if it's a jury of our peers. But talk to me about the process of selecting said jury. I know there are many.
Okay. Okay.
There are many that if their name called, like there are many who try to pull themselves out of that. They don't want the headache, they don't want the stress, especially if it's a high-profile case. So I know there are many who might not actually mind not having to go and sit in a court and listen to these cases, you know.
Right. Okay. Yeah. So let's deal with it. First of all, let's just clarify for the public the difference between the two. In a jury trial, it means that the judge remains the arbiter of the law. So the judge is the one who makes the final decisions on the law. He gives the jury guidance in relation to the law, and the jury have to accept his guidance as to the law and legal matters. The jury, however, remain the sole arbiters and they're the sole ones to determine the facts of the matter. So in other words, you use the law that the judge will guide you on, but you apply it to the facts that you find. So in other words, regardless of what the law says, if on the facts you find that the offense was not committed, then of course that's your decision as members of the jury. And we need to understand the importance of that. And you see, particularly for defense, criminal defense attorneys, the jury forms an important part of their arsenal, you know, because the point is they play to a jury. They make their addresses to the jury, and they are able to convince the jury on their points if it is that they are able to marshal the facts and the evidence in a way that suits the interests of their client. We all remember the greatest closing argument ever in history of law in terms of a criminal matter was what was given in the O.J. Simpson trial. You know, when Johnny Cochran, you know, I mean, the whole world was sitting agog listening to him. And the way he wove his arguments together and then brought it to a climax in that one seminal line that resonated with the jury when he said, if the glove don't fit,
acquit.
You must acquit.
Yeah.
And that's exactly what happened. Now, I mean, in reality, Jason, you know, we all very strongly suspect that OJ did kill Nicole and her boyfriend. We have little doubt about that, but that's not the issue. The issue is what was the finding in the court. And that's where, for a defendant, they may feel that, look, I don't want to lightly give up this jury trial because at the end of the day, they are my peers. And that's an important aspect of it to consider, because in a judge-alone trial, it's the judge who is now both the sole determinant of the law and the sole determinant of the facts. I'll give you an example, Jason, from a Caribbean territory. I was speaking with someone recently, and in that matter, this young man from a depressed area, you know, he had been arrested by the police, and while at the police station, he was subject to, you know, some, you know, most egregious abuses by the police officers. And they filed a constitutional motion. And the judge sitting on the matter, who was, and, you know, to put it delicately, a lighter shade of pale, you know, he told the, you know, the person bringing the matter, and he told the attorneys, and he said it in open court, that, you know, he cannot believe that police officers will really do that, because he had, you know, been to the police station recently, and they treated him with such deference and respect. And, you know, I mean, and the person, you know, said, well, you know, that's exactly the problem. Because in other words, the way you experience life, the way you encounter life is totally different from how, say, for instance, someone from Beetham or Laventille may have their encounter with the police. So therefore now, someone who is going to a criminal matter and opting for a judge-alone trial, they may very well feel that, look, there is a chance that this judge lives in such a different reality from what the ordinary man in the street knows, that some things they just cannot even wrap their heads around. Now, I mean, in reality, in Trinidad and Tobago, I know most of our judicial officers are firmly grounded, and, you know, they are ordinary people, you know, once they, you know, in their normal daily lives. So they, in many ways, understand these things, but there may still be that chance that some of them may be so detached and distant from the reality on the ground that they may not be able to have that empathy or that understanding that a jury of your peers may give you. And as a result, you may find persons preferring to opt for the jury trial. So I think that's why you have such passionate discussion and debate about it, because people feel that, you know, you really are putting yourself in a scenario where if your only option is a judge-only trial, then, and I mean, as I say, look at the statistical evidence from Australia, where it shows a much higher rate of conviction. Because in other words, look at that OJ speech. The glove, if the glove don't fit, you must acquit. That may not have, found any resonance with a judge. The judge may say, well, okay, look, despite that, there's more than sufficient evidence that, I could find to convict. But the point is, remember, you also had the other factors in that OJ matter, where you had, the Detective Furman, who was proven to be a racist, who, seemed to have an ulterior motive, who seemed to want to plant evidence. You had
I remember that. That was the
yes, Cato Cralin. So there was so many other factors.
That was the trial of the century. I remember that case
right,
well.
That's right. And the point is, in terms of a jury, these were the factors which, at the end of the day, made the difference.
Martin, I want to pivot really quick because the jury in the court of public opinion seems to be, seemed like they would have made their decision concerning the Minister of National Security, especially the Law Association. Now, he would have made utterance. Now, I'm not sure if indeed it's because of his role and function in the seat that he occupies at this point in time that caused the alarm. There are many asking for an apology. If the statement he made is indeed factual, we will never know if he went on opinion or on facts, information that he knows himself. But it was indeed a most alarming revelation, claiming that criminal elements had friends in high places, including the judiciary. What's your take on that development, Martin?
Well, the thing is, you see, to just throw that statement out there as a broad blandishment, and you make it as a sweeping statement which affects all members of the judiciary, and to not provide the factual matrix or the supporting evidence to justify such a statement, I think that's where everyone is finding fault with it and taking issue. If it is that you have specific, detailed evidence that you are laying out in the public space to say, well, look, there has been, this investigation and these persons are going to be charged and they are members of the judiciary or, something of the sort, then by all means, then you do so in a responsible, serious manner and you explain yourself. You don't just appear to be making a knee-jerk reaction and a statement coming as it did, in a very curious timing with the Brent Thomas judgment, And in fact, he was actually commenting specifically on that judgment. So therefore, when you throw that out there, how is that sitting judge to feel? How are other members of the judiciary to feel when you just make that type of statement? And you see, there is a double and maybe triple responsibility on Mr. Hines in that regard. Mr. Hines was a police officer, so he knows that level of responsibility that is required. He's an attorney at law. He knows that he took an oath of office. He's an officer of the court. He's a politician. He's a member of parliament. He's a minister of government. So you are wearing several hats, and you have had enough experience and exposure to understand the import and impact of such a statement. And then you saw the Attorney General coming out to try to explain what Mr. Hines said and to say, well, he didn't really mean that. And, and it's so reminiscent, Jason, of, when President Trump was in office and he would make these most outrageous statements. Mm-hmm. And then you'll see the White House press secretary trotting out and other senior Republicans, coming out to try and explain it away to say, well, even though it may have seemed that way, what it really is, come on.
Remember,
let's be serious here.
Words are expressions of a thought, and I'm sure that is something that would have been in his mind probably for a while, and I'm just trying to figure out if indeed the forum, the place, of course, as you would have mentioned, his role and function at this point in time, which is indeed a very important one. As we say in local parlance, local words, it was more or less out of timing. But I wonder if he knows something that we don't know.
No,
and he decided to say that intentionally to shake the cage.
If you do, then you need to provide the evidence to support the statement. You don't just throw it out there, as gambage, as if you're in the Gael, and it's stick fighting, and you make a feint and a shake and no, this is serious business, and you're talking about the pillars of our society. So you do not do that willy-nilly and in an attempt as if, well, I was just making a bad joke. No, that's not a joke at all. It's not even in the least bit funny, and he must have known better and ought to have known better if it is that he did not or does not have the factual matrix, right? So, I mean, I'm still giving him the benefit of the doubt that if he does have that, then of course he has a duty to produce that evidence.
Of course.
But if he does not, and if he never did, then it does appear that the criticisms that persons are making from all quarters, it does appear that those criticisms are very well founded.
As we said.
Because you see, Jason, just in closing, I want to remind the public of the 1936 Privy Council decision of Ambad versus Attorney General, where it was stated by Lord Atkin that justice must not be seen as a cloistered virtue. She must be allowed to suffer the harsh but respectful criticisms of ordinary men. So in other words, we're not saying that judges and judicial officers are immune from scrutiny or criticism. In fact, look at our history in Trinidad and Tobago. Remember Patrick Jagassar, a magistrate who was convicted in relation to an allegation of taking a bribe. If you understand me, remember we had a former Chief Justice, Sat Sharma, who was charged and placed before the court on an allegation of conspiracy to pervert the course of justice. So the point is, no one is trying to say that judicial officers are immune from scrutiny. But if at all you are to do so, it must be done in a serious and respectful manner, and a manner that is underpinned by evidence and facts. You cannot be just casting these broad aspersions, and particularly in your role as Minister of National Security, because, as you say, based upon his vantage point, there may be some persons who think, well, maybe he really knows something, maybe he has some information.
I was thinking,
and my point is, if you do, then in a responsible manner, you come out and you present it. And you say,
Martin,
this is the reason why I made the statement.
I want to get a comment on you before we wrap things up officially and get across to the 7 a.m. news update. The Commissioner of Police giving her rating as excellent, quote unquote. Your reaction to her statement. I said this morning, sometimes no comment is a comment, but she decided to comment and she said her first 100 days were excellent.
Well,
in the remaining time, we have a minute.
What I would say in that regard is, in my days at St. Mary's College, my only troublesome subject was Spanish. I was good at the sciences, good at mathematics, good at the English language, good at everything else. Spanish was the only subject that I had so much difficulty wrapping my head around, this foreign language. And of course, it was exacerbated by a scenario where, for some strange reason, in Form 4, we had Spanish and French as 2 consecutive class periods with the same teacher. So at no point in time I knew which class I was in. It was all Greek to me. But my point is, if I had the Commissioner of Police grading me for my Spanish exam, I think I would have gotten a 1+++ in that exam rather than the 2 I got. So that's all I will say in that regard.
Understood, Martin. As always, thank you for your time, and we will touch base soon.
Thank you. Have a great morning.
All the best. We get ready for the 7 a.m. news update and so much more still to come on this Monday morning. Welcome, and let's have a great one today, Trinidad and Tobago. See you soon.